promised, Steve and I were talking about this last time. We were going to bring on an attorney to talk about tenants' rights.
Derrick, I'm so
and
excited.
You have done this.
I'm so excited. This is going to be a show where I'm going to sit back and not say anything. I will give a quick little testimonial for Eric. I have known Eric quite some time now, a couple years, and I, as an agent, of course, get a lot of calls about tenants' rights. Hey, I'm renting this place. Hey, my landlord didn't do this. Or, hey, Steve, you helped us purchase an investment property. I always reach out to Eric. He's always got the information and knows it inside and out. And so I'm just going to pull out my, I'm going to pull out the water. I'm going to pull out my notes here, and I'm going to do some learning.
Eric Ransavage, thank you so much for coming today. Appreciate your time.
Thank you for having me.
I think it is an interesting conversation, and you know what brought it up the last time Steve and I were discussing was I was speaking with a lady who wanted to buy a home. And her landlord had basically sort of made her feel like she was somewhat trapped, that she had to be out by a certain date, or she had to sign new terms that weren't as good. So she had to sign a new lease at a higher rental rate, and she didn't have very much time to make that decision. So she either had to buy a house really quick, or she was stuck in a new lease. So that's where this sort of originated. And I, of course, always disclaim I'm not an attorney, but I believe that they have to give you 60 days notice if they're going to change terms or if they want you out. So you always have that 60 days. And if no one says anything, and you can correct me if I'm wrong on this, then your rent stays the same. And as long as you keep paying it and there's no notice filed, then you just keep going, even if you had a 1-year lease to begin with. Is that right?
Right. So you've hit on a lot of issues there. You know, let's talk about the notice issue. So the notice, how much a notice a landlord needs to give you as a tenant, and how much notice you as a tenant need to give a landlord. Let's say if you're going to leave or do something, is based on the period of time that the rent is collected. So typically rent's collected every month, right? So that's 30 days. For a landlord to do something to give notice to a tenant, it's going to be 30 days notice, and likewise for a tenant to let a landlord know, hey, I'm moving on, that would be 30 days. Now that's in a situation of where it's just a rental agreement, what we call a month-to-month tenancy. So you had mentioned, well, maybe they had a lease for a year, and what's a pretty standard operating procedure is 1-year lease, the lease is up, and a lot of times in the written lease it'll state that once the lease is up, this will become a month-to-month tenancy, or even if it doesn't, if the tenant continues to pay the rent on the same day, you know, the 5th of the month, it becomes a month-to-month lease. So to get out of that lease or for the landlord to do something, it's a 30-day notice. However, unless you've been there for more than a year, if it's more than a year or more, then it's a 60-day notice. So you mentioned the 60-day notice. So yes, in San Diego County, if you've been in the unit for more than a year, then the landlord would have to give you a 60-day notice. Now, having said that, you can always, what's written in the lease is going to trump everything. So if a tenant and a landlord have a 2-year lease or 3-year lease, and the landlord wants to give some sort of written notice, then that's going to be included in that lease. The lease is just a contract between the landlord and a tenant. So my advice to tenants, of course, is always make sure you read the lease and make sure you understand everything that's in there, because that's what you're agreeing to with the landlord. And with some exceptions, that's the way the law is going to look at it, which is you agreed to this, so you know whatever goes on down the line, that's what you agreed to. So, you know, for a tenant, really having that periodic lease, a 1-year lease, a 9-month lease or whatever is good protection, and also protection against raising rent, because the landlord can't raise rent unless there's something in that lease that allows them to do that. So that's under a written lease. Again, with a month-to-month tenancy, then there are some rules where what happens because you don't have a lease anymore, what happens by default. Can a landlord raise the rent by a certain amount? And yeah, there's a rule there that says they need to give 30 days. If it's 10% or less, they need to give you 60 days if it's 10% or more. If they're changing other material terms of your agreement, they need to give you notice of that as well. So 30 days typically.
So
I'll throw. Go ahead.
I've got some questions here. So, so let's say I'm in a 2-year lease. I'm a tenant, and then the lease comes to the end of the term, and my landlord hasn't notified me that they want to put a new renter in. So it's the end of my 2-year lease, and I didn't communicate. They didn't communicate. It's not a situation where then all of a sudden they can say, "Hey, I told you from the get-go that our lease was expiring on June the 1st. It's now June the 3rd. Sorry, you got to go."
Right. So the lease is the one item where the notice is really built in. So normally when a landlord needs to or wants to evict a tenant, they need to give you a notice. Anytime you're going into an eviction courtroom, which is unlawful detainer is what we call it in San Diego. So an unlawful detainer courtroom, the first thing the landlord needs to show is that they gave you some sort of written notice, a 30-day notice, 60-day notice, or if you didn't pay rent, a 3-day notice. However, a lease gets around that because the landlord's, it's written into the lease that, let's say June 1, you're no longer the tenant.
I'm no longer in contract.
That's
so
correct. That's correct. So at that point, the landlord can say, it's June 2nd, you need to vacate the way we've, the way the lease states. What happens many times under those scenarios is that and there may be other language written into the lease as well that tells you, here's how this is going to end,
Right.
Here's how you're
It defaults to month to
right.
month or something.
And the landlord, again, may say 30 days before, Steve, this is a reminder that you're up in a month. I'm not going to renew the lease, so this is your notice that, you will be done as of June 1st. What happens under a lot of circumstances is June 1st comes around where the lease is done, but you send in the check, landlord cashes the check. Well, now they've just created a month-to-month tenancy. So basically they're now extending this lease on a 30-day basis every time that you send in that check. So that's a fairly typical scenario in San Diego County, is that, if the landlord's doesn't mention anything and they accept the money, then you're creating a month-to-month tenancy.
And as a landlord, you said less than 10% increase to the rent that I need to give 30-day notice, but more than 10%.
Mm-hmm.
I was under the assumption that you couldn't raise the rent more than 10%, but I can raise rent to whatever I want. Is that what you're saying?
Right.
With enough notice.
With enough notice, but also based on, and I'll have to be the lawyer here and say there's some caveats because there are rent control jurisdictions,
Right.
Oceanside or San Francisco, they have some specific rules about how much a landlord can raise the rent. And then you talk about San Francisco, there's a rent control board which tells the landlords, this is the most that you can raise rent this year. So with that, if you look at the way the law is written, you've got state law that covers everything, but then you have these individual jurisdictions that can actually be more restrictive. Again, City of Oceanside, the City of San Diego has some more restrictive rules that protect tenants more than landlords, I would say, or more tenant-friendly. So having said that, you can raise the rent as a landlord certain percentages, but you have to provide the correct notice.
So
and I will say, not to interrupt, but that's also assuming that it's not written in a lease, because in a lease, as a tenant, you could negotiate over the course of this lease, the rent will not be raised, or if it's going to be raised,
Right.
it will be raised certain.
So the lease always
amount.
trumps. But as a landlord, if I'm looking for a way to get rid of my tenant, and I don't feel comfortable telling my tenant, hey, I'm just tired of you, I want to get rid of you, I could say, hey, I'm raising rent. Here's your 60-day notice because you've been there for more than a year. I know we're charging you $2,000, but I've come into some financial dire straits, and now whether it's going to be $3,000 a month.
Right.
And of course, they're going to say, I can't do that. That's a 50. But I can do that kind of, that's a 50% increase in rent. I'm allowed to do that with enough notice.
You are, but you wouldn't even necessarily need to go to that point. If you have either let's say the written lease is up, or you have
Oh, yeah.
a month-to-month tenancy.
I could just say I'm not renewing.
Right. The typical way a landlord ends the tenancy is either through a 30-day notice or the 60-day notice. And you had mentioned, well, you don't want to tell them that you're tired of them. Yeah, those two notices there doesn't need to be a reason. It's real simple. You just say, and those forms are online. You can find them. The one thing I will say is San Diego and most jurisdictions in California are going to protect the tenant. There's a public policy where we don't want people thrown out of their homes on the street unless the landlord does everything by the book, checks all the right boxes on the forms and dots their I's and so forth. So that is something where a landlord may want to get an attorney and have them look at even a 30-day or 60-day notice to make sure it's done properly. It has to be served properly. So those notices, for example, you can personally serve them by handing them to your tenant. But if your tenant's closing the door and not opening the door, then there's some other ways you can serve that on them by posting it on their door and mailing it to them. But those have to be followed correctly. And I've seen many cases in unlawful detainer trials downtown where, the landlord just did something a little bit wrong, incorrectly, and the judge dismisses it and says, well, that's what the law is, and which...
So you could have a year-long lease, give them, if I'm the landlord, year-long lease, hey, it's month 11, I'm notifying my tenant, hey, here's your 30-day notice, I will not be renewing with you. Of course, 30 days, especially in San Diego County, to find a rental, move, that can be difficult. You're saying that as a tenant, even though the tenant would be in, I don't even want to say in breach of the contract, because they're not in a contract anymore, it was a year-long contract, and come June 1st, or whatever the day is, that they would be out of that contract. As landlord, I can't say, hey, obviously I wouldn't want to deposit the money from the tenant. If the tenant on June 1st sends me another month's rent, don't want to put that money in the bank and say, no, we're not doing this, I'm finding a new tenant. But it's not as easy as get out.
Right. And so one thing that kind of mystifies some people, or you do see this where a landlord will lock somebody out, or just lock the door, change the locks, and say, hey, the lease was up, you've now got to get out of here, and that's illegal. So if you're the tenant and you show up and the landlord's locked the door on you, or changed the locks, or done things to make it not livable for you, like they've shut the gas off, that is illegal, and the tenant's remedy there is to call the sheriff and say, hey, and then the landlord could say, hey, but you know what?
I've got a lease, and it's
I gave him the
expired
30-day notice. I gave him the 60-day notice. Well, the sheriff and no one's going to evict anyone in San Diego County unless they've got a court order. So that landlord, fortunately or unfortunately, has to go downtown, first give you the notice, serve the notice properly, then file a unlawful detainer action downtown. The unlawful detainer actions are given preference, so when both parties are in the case and ready to try the case, the rule is 20 days. And so 20 days from that point where the tenant has answered and the landlord is in the case, then we have a trial. And it's just like, which again surprises folks, it's an actual trial, so there's a judge there. The tenant can produce their evidence. And if at the end of that trial the landlord has prevailed, then there's another form, a writ, that gets served on the tenant. The sheriff puts that form on the tenant's door, and then 5 days after that, they can come and physically, forcibly remove you. But the bottom line is that whole process takes 3 weeks to a month, even from the date that the notice has gone up.
And so then as a landlord, how about damages in terms of, hey, I've lost out on potential rent here because it's gone. I was thinking about, if I received a check, I wouldn't want to deposit it, but most people pay their rent by like electronic transfer, where it's automatically coming into somebody's account, where then as the landlord you would want to turn around and send that money back, right?
Right, if your intent is to not continue renting to them, yes, by accepting the rent, you're creating a defense to an unlawful detainer action, which is that you implicitly created a new tenancy. And so,
Yeah, you don't want to take any money. It's just interesting. There's so many
Right.
layers to it. So is there damages that the tenant would be forced to pay potentially if you said, hey, you dragged your feet for 3 weeks on this, you said 20 days, I gave you a notice, I did all the correct things, we did go through this process, I lost out on potential rental income, by the way, you left the property dirty, that would be, I guess, a security deposit.
Yeah, that would, right, that would be a security deposit issue. If there was a breach of the lease which caused the landlord to not be able to rent the unit, yes, then that would likely be a small claims action for those
so then
damages.
It'd be another.
Right, and so those can sometimes be included in the unlawful detainer action. What typically comes in an unlawful detainer action is on a written lease. Typically, there's a attorney's fees provision in there, which is the prevailing party gets their attorney's fees. So if they go to trial, the tenant loses, then typically part of that judgment is going to be the cost of reasonable attorney's fees. So, I'll see $1,500. Typically it'll be. It's not going to be, an unreasonable amount. The damages to the unit, cleaning and things like that, are going to be covered by the security deposit. So typically, as part of a judgment, it'll note that. That security can also be used to pay the last month's rent if, for some reason the tenants left, vacated, and didn't pay the last month's rent. So that is can be used for that in California.
And you talked about both parties bring evidence to the judge. I imagine that the number one piece usually brought as evidence by the tenant is, hey, the property was unlivable. Hey, the lights didn't work. The refrigerator was moldy. They never cleaned it. I always had to deal with the trash, blah, blah, blah.
Right. So on a 30-day notice ending a tenancy or a 60-day notice, there aren't many defenses that a tenant can avail themselves of. It's basically your landlord's given you notice, the tenancy will be over. The exceptions to that are things like retaliation or discrimination. So if there's evidence that the landlord's giving you a 60-day notice for some sort of discriminatory issue, race, religion, things like that, right, then that may not fly. Retaliation, it would be, for example, where a tenant calls the city of Carlsbad and says, hey, my landlord's renting me a unit, there's a whole bunch of mold in here, there's a water leak, and the city of Carlsbad comes out, cites the landlord, and if the landlord were to turn around within a 6-month period and try to evict you, then the law is going to look at that and say, you know what, we presume that the landlord is trying to evict you for a improper retaliatory purpose because you called the city of Carlsbad on them.
So the same idea being that if it was repairs, I know some tenants are afraid to ask their landlord for repairs because they're concerned that my landlord is going to kick me out if I ask for too many repairs.
Right, and that would be illegal. Yes, if they were to try to, remove somebody for availing themselves of their legal, what they can do legally, which is to ask for repairs, then that would be improper. The retaliation, whether that's not going to protect the tenant forever, the tenant doesn't get to live there forever, right? I mean, if it's that you called, the city of Carlsbad for some issue, but that was a year and a half ago, and now the landlord's saying, well, I want to end your tenancy, that's going to be something for a judge to decide. But to go back to your point about what we call the legal term, the breach of the warranty of habitability, which is that, as a condition of paying rent, the landlord needs to provide habitable premises to the tenant, and that is usually the biggest, thing that comes up either when the landlord or when the tenant's filing their what they call an answer, which is their response to the complaint, and many times that's what's being brought before a judge, which is, the landlord was renting me a place that, again, had leaky windows, or the electricity didn't work, or didn't have heat, didn't have, I was going to say air conditioning, but that was from my Las Vegas days, where if you're renting in Las Vegas, you need to have air conditioning, right? San Diego, maybe not so much, but
it sounds like not a crystal clear answer on that.
Not a crystal clear. No, there are certain things where, I mean, again, if if you're missing windows, broken windows, there's some specific items that are set out in the law that you need to have: locks, security locks on the doors, a mailbox that can lock. So.
Interesting, a mailbox that can
Well, I
lock.
think that would be in a condo or an apartment, not necessarily in a
I like how
single
Steve is
family
taking this segment off. So let's get to some juicy questions.
home. Yeah.
Oh,
All
yes.
right, let's do it.
So now, and I'm not anticipating anything drastic happening, but we saw this happen about 10 years ago when foreclosures really spiked. That some people were not paying their mortgage, some landlords were not paying their mortgage, but they were still collecting rent from renters. And I know some renters said, hey, I got a notice in the mail that my landlord hasn't paid the mortgage. Like I opened it thinking it was my mail or whatever and realized, oh, shoot, they're behind. Well, I've been paying them. They haven't been paying the mortgage. We're all going to get kicked out of here. So how do those lines cross, for like if the landlord is being foreclosed upon, for example, first and foremost, is your rental agreement still valid at that point?
Yeah, good question. And there's a lot of legislation that spun out of the 2008-2009 financial crisis where that became a situation where landlords weren't, someone realizes, I own this house, I'm upside down in it, why would I keep paying the mortgage? I mean, obviously there are reasons why you would do that, but it became a fairly common practice. Bottom line is, the mortgage is a contract between the owner of the house and a bank, so it doesn't include the tenant. So the short answer to your question is, yes, the rental agreement is still in effect and the tenant still has a duty to pay the rent, even though the owner may not be paying the mortgage anymore. The bank, their way they deal with these issues with the owner is to foreclose, which then brings up the issue of, okay, you're the tenant, and actually, by the way, I mean, talking about Vegas, where I did live for a number of years and did practice in this area law, it became an industry where, whole sections, neighborhoods, the owners weren't paying the mortgage anymore. The homes were, worth 40% of what they had been worth, but they had tenants, and there was, scenes where landlords were saying to tenants, I'll rent this to you at a great deal, a really cheap price, but you need to be ready to leave on a few days' notice because I'm not paying the mortgage anymore and the bank may come knocking and foreclose on me. And so, and especially with the glut of foreclosures, and if you remember back in those days, sometimes it would take
years,
especially in Clark County, Las Vegas, and here in San Diego as well. Yeah, years for the banks to get caught up and finally foreclose on some of these folks, and the owners were collecting rent. And if you're a good owner, you were upfront about it and say, I'll rent to you at a lesser amount, but yeah, we may be getting a notice and you'll have to get ready to leave. So those were valid leases, at least in Las Vegas when I practiced there. But going back to the point of a rental agreement, yeah, that's still in effect no matter what the landlord is doing with regard to.
So you still owe the rent.
You still owe the rent.
But if you're paying the rent, then your rental agreement is still in place, even if the owner, the landlord, gets foreclosed upon. Now the bank owns the house. They have to oblige.
Honor the lease.
Right, and so that brings up a change that did occur around that time frame. So there were laws passed which, in order to protect those tenants in those situations where a tenant was paying his or her rent, the house gets foreclosed on, and depending on the time frame, now they have to go and find some place to live. So there were changes there on the federal level, and I'm sure on the state level as well, where the bank or whoever buys the property or whoever owns the property does have to abide by that lease. And so if you're the renter and you had a 1-year lease and the house gets foreclosed on and you still have 6 months left on that lease, whoever now owns it needs to honor that lease. And the rule there is, would be a bona fide lease. So if you're the owner of the house and 5 days before your foreclosure, you go to your buddy,
which
Steve,
I've heard of,
and you say, here, I'm going to rent you, I'm going to write up a 1-year lease with you, and you're going to pay $100 a month on this 4,000 square foot house. That's not a bona fide lease. That would be looked at as something where you were trying to get around, use that law and get around some things. So if it's a bona fide lease, yeah, then that lease is going to stay in effect even when the house gets foreclosed on.
Okay. What about, there's been a lot of law changes in the past few years regarding like marijuana, for example. So it like became recreational use. I think that was this year. Was it this year or last year that became
You're
official?
asking the wrong guy.
Yeah, I don't know. So either this year, January 1st, or last year, January 1st, recreational became, no, it had
Legal.
It was from the election, which was 16, so maybe it was 17. I don't know. No, it was 18. It was 18. It had to be 18. So January 1st, 2018, I believe recreational use became legalized, meaning that you can just be 21 years old or whatever, walk into a weed shop and buy whatever. And then, but I know there are a lot of people, I mean, it was like a really close vote. It was like 50-50, it was like 51-49 or whatever. So there's a lot of people who still think, hey, no, we're going by the federal interpretation of this. This is a class 1 drug. And so I would imagine that a contingent of that 49 or 48%, whatever it was, are landlords, and would probably say, I don't want any of this. So does that go to the lease? Can you supersede the law with the lease, or if your lease doesn't say anything, does the law become the prevailing word?
Yeah, so there's a lot going on there, and we see a lot of it in our practice where tenants are asking these questions. So California passed the law, but according to the federal government, it's still a class 1 narcotic, or I'm not sure how it's classed, but it's still illegal. And under the supremacy clause of the Constitution, the federal government trumps the states. So, that's one thing the landlords can always hang their hat on, is to say, all right, let's find whatever California's done here, but it's still considered illegal on the federal level. Bottom line is this: so the landlords can put in their lease, no smoking. So there are smokeless apartment buildings now. So any of those reasonable, considerations can be put in there. So you're going to get so if you're a tenant and you like to use that stuff, you just need to look and make sure and see what you're agreeing to. What's in that lease? Is it a smokeless building? Are they going to, put up a fight with that? Where it gets into a grayer area is now where people are getting prescriptions or letters from doctors where they can use marijuana because of pain or some illness. And that then brings in this issue of someone with a disability, where a landlord needs to make reasonable accommodations to a tenant that might have a disability or might have an illness. And so I've seen it where tenants say, you know what, landlord, I've got this issue, I've got this pain issue, or I've got an illness. This is something that's prescribed by my doctor. You need to make a reasonable accommodation for me and allow me to do this. It's, I don't know of any case law or courts that have decided yet, 100% either way, whether that requires an accommodation or what type of accommodation. The issue with smoke, of course, is it's going to get, if you're in an apartment building, it's going to get around the building and through. So I've seen it where the tenants say, hey, I've got a right to do this. They can use it to negotiate a little bit, but it's clearly not a slam dunk where they can say, yeah, I should be allowed to do this, and there's
Just
nothing you
because
can
it's
do
legal.
about it.
Okay.
What'll happen in those situations is, we talked about breaching a lease or breaching, a rental agreement. If the landlord doesn't, considers it to be a breach, then they have to provide the tenant with a notice, a 3-day notice saying, we consider you to be in breach of the lease agreement. Why? You're using drugs, you're using marijuana. You've got 3 days to correct that and not do it again. And if so, you're fine. But if not, then we'll proceed with eviction proceedings.
Tremendous stuff.
I have one final question. Can I ask a very quick question?
I thought you were going to be quiet.
I did think I was going to be quiet, but it's such an interesting topic. So here's my final question. So you talked about marijuana use, etc. It made me think, as a landlord selecting a tenant, how can you make a decision if I have 5 students? With the discrimination, etc., if I have 5 students that want to rent a place versus one guy versus a family versus Section 8, how, as a landlord, can I make a selection that allows me to fall within the law and choose I mean, what are the requirements? Is there things that prevent me from choosing one tenant over another?
Right, as long as you're not discriminating, if you want a reasonable clause in your lease that again is no drug use, and you're not using that in a discriminatory fashion, meaning you're going to enforce that against anybody, no matter whether they're 18, and look like a skateboarder, or whether they're 50. The point is, as long as you're enforcing that in a non-discriminatory way, that's going to be fine. The issue, for landlords is, when it comes to things like, how many kids might somebody have, or again, their race or religion, you can't use that as a basis to make a decision. Credit report, how much what their income is, those sort of cut and dry, or issues that are just not based on race, religion, anything of that nature. Children, whether someone's pregnant or not, age. The age, the exception to that is there are the 55 and older communities and 62 and older communities, so that's not considered discriminatory. But if you're using clearly if you're a landlord and you tell a 21-year-old kid, I don't want you here because you're 21 and I think you're gonna,
lose your
smoke
job.
dope, that could be considered discriminatory on the part of the landlord. There is for the benefit of tenants, there's a California Department of Housing and Employment that can investigate that as well. So that's the one area where they'll get involved in landlord-tenant type issues, the only area where they'll get involved in landlord-tenant type issues. And you can say, I've been discriminated against because of X, Y, and Z. Obviously, smart landlords don't do that. So
I love it.
Be a smart landlord and make your friends smarter than everyone else. Share this video right now and drop your comments in the comment section below. Eric Ransavage, thank you so much for your time today. Steve Ploetz, thank you for doing all the interview work.
You're welcome.